Well, good morning, everyone, and welcome to our Town Hall for Notaries Public. Today's topic is Notaries Public versus title insurance producers and independent contractors. What's the difference? Well, there's a big difference, and we'll learn about that this morning. My name is Kathy Smith, and I am honored to be Maryland's Assistant Secretary of State. I provide executive oversight of the Charities and Legal Services Division of the Office of the Secretary of State. I am delighted to introduce you to Maryland Secretary of State Susan Lee and the Commissioner of Maryland's Insurance Administration, Kathleen Barain, both of whom would like to welcome you this morning. Secretary Lee?
Yes, hi, everyone. Hello, I'm Maryland Secretary of State Susan Lee, and I'd just like to thank and welcome everyone for participating in this very important town hall. I'd also like to thank, of course, my Assistant Secretary for Charities and Legal Services, Kathleen Smith, who's on here today this morning, and the Division Administrator, Michael Schilling, and the Maryland Insurance Administration Commissioner, Barain, and her wonderful team, including Marian Akamade, for their work in presenting this important information, not only on how to become a notary, but if you're already a notary, be compliant with our requirements, and also to just be on top of the latest development and trends in the notary field. And we want to apprise you all the information and resources that you'll need to succeed and to be the best in this field. Again, thank you for your participation and my best to everyone. Thank you.
Thanks so much, Secretary Lee. Commissioner Barain?
Well, good morning. And again, thank you very much for the opportunity to kick this session off. I'm Kathleen Barain. I have the honor of serving as the Insurance Commissioner for the state of Maryland. The Maryland Insurance Administration is the state agency that regulates Maryland's $46 billion insurance industry. That includes the regulation of companies and the licensing and regulation of insurance professionals in our state. Now, you may wonder what that has to do with you as a notary, but I understand that many of you want to conduct real estate settlements, and as a notary, you can do so. You can act as a title insurance producer independent contractor. Those are the folks that conduct settlements and help procure title insurance. My staff is here to explain in more detail what is required for you to be able to do that legally in the state of Maryland. The Maryland Insurance Administration licenses insurance producers, including independent contractors, to make sure that they are competent and that they are trustworthy and they understand that the rules that they have to follow. Real estate settlements are the largest financial transaction most people engage in. So those licensing requirements are in place to protect the consumers who are buying or selling property. The MIA also protects the public by investigating complaints about title producers who have not followed the rules and may not be competent or trustworthy. So I know that each and every one of you that are interested in participating in this element of the industry and doing closings and real estate settlements wants to do the very best job that you can do and wants to do so with competence and trustworthiness and within the bounds of the law. And so what my folks are here today is to help make sure that you know how to do that. So again, welcome, and I hope that you, in fact, I know that you will find this session to be both informative and instructive. Thank you.
Thanks so much, Commissioner Barain. We're so thrilled you joined us. With me today also is our Division Administrator, Michael Schlein, and the Maryland Insurance Administration's Associate Commissioner for the Market Regulation and Professional Licensing Unit, Mary Clay, and with her is Marianne Akamade. She is the Senior Compliance and Enforcement Officer for MIA. Our notary officers from the Office of the Secretary of State are also joining us this morning. During this morning's town hall, we'll address some basic requirements and qualifications to become a Maryland Notary Public. Ms. Akamade from the Maryland Insurance Administration, or MIA as they refer to it, will address the requirements to become a title insurance producer and independent contractor. The requirements and regulations are different for a notary than for a TIPIC. Listen carefully to distinctions and requirements of each. And as Commissioner Barain said, I know you'll learn a lot that will benefit you and all those you serve as moving forward. As indicated in the email notification about today's town hall, this town hall will be recorded. A link to the recording will be available on the Secretary of State's website under the Notaries tab. By choosing to join the town hall, you are consenting to the recording. Please know that the content and presentation is for informational purposes only. It is not intended to be legal advice. Let me repeat that. The content and presentation is for informational purposes only. It is not intended to be legal advice. Time is reserved at the end for questions, and you may find that your questions are answered as the presentations progress. You may place questions in the chat box if you like, and our staff will attempt to respond to those. But in order to prevent confusion about the source of the response, please do not answer questions in the chat box if you are participating in today's town hall. Let me repeat that. In order to prevent confusion about the source of responses, please, if you are participating as a guest, do not answer questions in the chat box. Unfortunately, we've had some well-intentioned people put some information that was outdated in the chat box, so leave that to our staff, please. Staff from the Office of Secretary of State will announce questions placed in the chat box at the end of our sessions, and we'll do our best to answer every one of them. And of course, we'll invite questions during the Q&A session at the end. Once more, today's recording will be posted on the SOS website under the Notaries tab. As we begin, you may keep your camera on if you like, but please mute your microphone. Without further ado, allow me to introduce our Division Administrator, Michael Schlein, and then followed by him will be Ms. Ackenmaid. Mike?
Thanks, Kathy. Good morning, everybody. Hope everybody's doing well this morning. Like Kathy said, we're going to talk about notaries and title insurance producers and the differences between the two. First, we're going to start with notaries public and notary law. Sources of legal authority for notaries is found in the Maryland Constitution and the Annotated Code of Maryland and the Code of Maryland Regulations. So Title 18 of the Annotated Code and Code of Maryland Regulation, which supplements that law. So there are certain requirements to become a notary, and starting with that, how do you become a notary? You apply on Renew Online. You're going to have ID with proof of residence, so something that verifies your home address. Complete the application, current driver's license or other non-driver state ID card, and payment are just kind of the very high level. This is what you're going to need. So drilling down a little bit into this further, what are the qualifications to become a notary? Well, first, you have to be at least 18 years of age. Second thing is good moral character and integrity. A third one is either a resident of or have a place of employment or practice in the state of Maryland. So living or working in Maryland, in a briefer way of saying that. If you live in Maryland, you're going to be a resident of the senatorial district from which you're appointed. And if you reside outside of Maryland, you have to be working in the state of Maryland, and your state in which you reside has to allow people that live in Maryland but work in their state to also be a notary there. And you can renew if you're not a new applicant, but you're renewing 60 days prior to your expiration, and up to 30 days after you expire is that window in which you can renew your notary commission. And effective October 1st, 2021, an initial applicant must also complete a course of study and pass an examination. And a renewal applicant must complete a course of study, though they do not have to pass the exam upon renewal, or when renewing, I should say. And offered by the Secretary of State, but really offered by one of our authorized course of study and examination providers that are private individuals or companies that offer the class and that are authorized to offer the class that you can use to renew or apply. So commissioning, what is commissioning? So a notary public is an officer of the state of Maryland, and by being an officer of the state, they receive a commission and they have to take an oath of office to take office or hold office as a notary public for the state of Maryland. So notary takes the oath of office at the clerk of the circuit court in the county in which they are commissioned, or Baltimore City if you live in the city rather than one of the other counties. and receive that commission at that clerk of the circuit court upon taking that oath of office. And you must do that prior to actually performing notarial acts. If you submit an application and that application's approved, you're not actually a notary until you appear at the clerk of the circuit court, take the oath of office, and receive that notary commission. So when you're taking the oath and obtaining the commission, what's going on here? Applicants are notified by email regarding the determination about their application. So we get your application, it's approved, you get a notice saying you've been approved, and gives you information about going to the clerk of the circuit court and getting sworn in. If it's denied, you'd get an email about that. But if it's approved, that email is going to contain the instructions about how to appear before the clerk, when, where, so that you can receive your notary commission. A notary must take the oath of office each time a commission is issued. So when you become a notary the first time, you go to the clerk of the circuit court. Every time you renew thereafter, you still have to go to the clerk and take that oath of office. That commission is not active until you've taken the oath of office at the clerk's office and receive that commission. So when you go to the clerk's office, you're going to pay an $11 fee to be sworn in. It's paid to the clerk of the circuit court, not the Secretary of State. That's a different fee from the application fee that you pay the Secretary of State to apply or renew. And the notary must be sworn in within 30 days of the issue date of the commission. The issue date is the same date as the approval email. So the day you get that email saying you've been approved, go to the courthouse and get sworn in within 30 days, you're going to follow the instructions in that email. Your 30 days start from the date that you received that email, the date we sent that email. And that must, and within 30 days, we have that highlighted, bolded, must is underlined, within 30 days is in giant text for a reason. You have 30 days to get that commission. Don't wait longer than 30 days. If you wait longer than 30 days, your commission can get revoked. That's going to get mentioned here on a later slide briefly as well. Get to the clerk of the circuit court, get sworn in, receive your commission within the 30 days. We don't want you to miss the 30 days. You don't want to miss the 30 days. If you miss the 30 days, the commission's revoked. You have to reapply, start over. It's not fun.
That's a really good point, isn't it? You know, so of course, this town hall is not the course of study. We all know that. But if you're renewing, you have to take the course of study, but you're not required to take an exam. But if you have to apply all over again, you need to take the course of study and the examination again, right?
You would have, yeah, if you were applied as new, you'd have to at least complete the exam. Again, if you renewed and you took the course, so you'd have to at least go back and take the exam. But yeah, you don't want to have to do it all over, right? You pay for it once. Why would you want to pay for it again?
Exactly.
Yeah, just get sworn in within 30 days. And best thought I can give anybody on the matter is, if you send in your notary application, you haven't heard anything in a week or two, reach out to us, right? Catch us proactively. Never just assume, oh, it'll get done, I'll hear whenever. Maybe we sent you the email and it got caught in your spam folder. Maybe it got blocked by your email server altogether. Who knows, right? But if you don't hear anything, check in. We'd rather you check in and check the status than call us 6 months later and say, hey, what's the status? And find out it's already been issued and it's already been revoked because of failure to pick it up within 30 days. So be proactive and ask for it. And ask us if you haven't seen anything. And we want you to succeed. We want you to get the commission. We don't want you to have to reapply. We don't want you to have the commission revoked. But the law says if it's not picked up within 30 days, it's revoked. So we don't want that to happen either. Don't let that happen.
So as you're going on, Michael, someone is asking if it's calendar days or business days.
Kathy, I think you might.
I was just saying,
Yep, there you go.
everyone please mute their mics. We'll have questions and answers later, but we'll continue. Thanks, Mike.
Yep, and it's 30 calendar days, by the way, 30 days. If you ever see 30 days, that means 30 calendar days, unless it's otherwise specified. So 1 month to get sworn in. So in terms of enforcement, can I have a commission revoked or suspended? Yes, yes, you can. A notary's commission can be revoked or suspended for failing to follow the laws, regulations, and other requirements of being a notary public. After an investigation, if the Secretary of State determines there's cause to revoke a notary's commission, the notary will receive notification of that intent to remove the notary from office. If you're a notary and you get a notice as such, you could contest removal and request a hearing held by the secretary or their designee. Those hearings are informal hearings. This is not a courtroom hearing that many people are familiar with, or you see from watching TV. It's not how that goes. It's not a hearing in front of a judge. It's an informal agency hearing where you can explain why you don't want to be revoked or you think we're wrong for doing it, and ultimately we would make that decision. I mentioned on the prior slide and went on for a little while about it. Commissions can be revoked if the notary fails to be sworn in by the clerk of the circuit court within 30 days of issuance. Key difference here is, if you're a notary and you get your commission revoked because you're already a notary, you have that right to the hearing, the informal hearing. But if you've never gone to the clerk of the court, taken the oath of office, you're not a notary. If your commission gets revoked for failure to pick it up within 30 days, you don't have the opportunity to request a hearing. It's revoked. So because you're not a notary yet, so your commission is revoked for failure to get it, take the oath of office and become one, rather than because you're a notary and have it revoked. So again, drive that point home. Get there within 30 days. It's no fun if you miss it. It's no fun for you. I assure you, it's no fun for us either. We want you to get that commission. Publishing information about notaries public. So the Office of the Secretary of State also does publish certain information about a notary. That is public information. The notary's applicant ID number, name, county in which they're commissioned, expiration date, and business phone number can all be found by searching a notary on our website. So if you're commissioned as a notary, your information should show up on our notary search page. That's the info people will see. We're not going to display home addresses and home phone numbers. They're not displayed. One important distinction on that too is that the notary's work address and work phone, or business address and business phone, are the address and phone number of public information. The only time a home address or home phone number becomes public information is if a notary does not maintain a current/valid work address or work phone number, at which time the home address or home phone would become public information. So keep your info up to date with us. That way it's your work information that's showing up online, not your home information. But if we don't have valid work info, the home address and phone number are public information at that point. So we also publish a list of remote notaries on our website. So if somebody's a remote notary, there's a list of them online. You can find yourself on the list that's authorized to do electronic records or tangible records, two separate lists, two different types of remote notaries. There'll be a whole remote notary town hall later this year. A few other pieces of business here about becoming a notary, just kind of the overall process. You're going to complete your application online. We're going to get it the next business day and start reviewing it. We're going to do a background check. If you've ever been convicted of a crime, say yes. You must disclose and explain that criminal conviction. Best way to have an issue in your notary application, if the answer to this question should be yes and you say no, we talk about good moral character. One surefire way to not meet that qualification is to provide false information on an application. So if the answer is yes, say yes, disclose it and explain what happened. You got a much better chance of getting approved if you do that than if you try to hide it. So convicted of a crime, civil judgment. So if you've ever had a judgment entered against you, you lost and a judgment was made against you in civil court, you disclose and explain again as well. Just, if the answer is yes, say yes. Reference checks are reviewed by senator. If the state senator is the one that can approve notary applications, many state senators opt out of the process as they're allowed to do it, delegate that authority to our office, the Secretary of State. And so if that happens, our office is going to email you references, and they will need to reply, or at least one of them will need to reply with a reference response in order to move the application forward. If the state senator maintains that authority to review the apps and does not delegate it to us, then the senator's office is the one responsible for contacting references or reviewing the app and making the determination. And then a determination is made, and if you're approved, like mentioned earlier, you're going to get an email about that telling you to go to the clerk of the circuit court, get sworn in, and remembering my emphasis on the get there within 30 days after you're approved. And if denied, an applicant is notified of the denial, so you'd get an email explaining, that your application's denied. Application process: gather the stuff you need to have before you begin the application. Understand and become familiar with notary public law, the regs, the handbook. The required course of study is very helpful in preparing you to understand this. It's going to cover the information in the handbook and the law and in the regulations. You need to know that in its entirety. If you're going to get a commission to do something as a public officer of the state of Maryland, you want to know what it is you're actually doing, right? That's the best way to succeed in that area is to understand and learn what your responsibilities are. If you start an application and you are inactive for 30 consecutive minutes, you are going to get logged out of the system. That information is lost. So again, make sure you have everything you need beforehand. So I mentioned on the earlier disclosing conviction or civil judgment, be sure to explain it. Family members and your actual employer may not be used as one of your 3 references. Coworker's fine, but not your actual employer. Photo ID must contain an applicant's address. If the applicant moved, they should attach the MVA change of address card indicating the current address with the application. So what does this mean? We're talking about completing your application to become a notary. You need to give us a copy of your state-issued ID that verifies your home address. If you're a Maryland resident, your ID is on your driver's license. And if you happen to move while your license is still active, you notify the MVA and they send you a change of address card. So if you've got a change of address card, attach that with your ID. The address on your ID/change of address card does not match that on the application. We're going to ask for it to match. We're going to need that change of address card if your ID has a different address than your application. So make sure that house is in order, so to speak, with your license and your change of address card, or your non-driver ID card and your change of address card if you've moved since you last got an ID. Notary must be sworn in within 30 days after the commission is issued. I won't pound that home again, but important, 30 days after the commission is issued. $11 fee charged by the clerk of the circuit court. So after you get approved, you're going to go get sworn in and pay them a fee. Thinking of fees. So as a notary, now you're a notary, you've been approved. What is it that you can charge to notarize? So now you can charge demand and receive up to $6 for the performance of an original notarial act. And remembering that this is the fee for each signature that you're notarizing, right? You're identifying somebody, you're watching them sign, administering an oath or affirmation or acknowledgement, or just doing the official witness, depending on the notarial certificate wording. And you can charge $6 per notarial act, up to $6 per notarial act. People often ask, can I charge less? Sure. Can I do it for free? Sure, absolutely. But you cannot demand and receive up to $6. People often like to ask you, well, what if they want to tip me? Nope, can't do that. You can demand and receive up to $6. So you can't demand more than $6. You cannot receive more than $6 per notarial act. So if you're notarizing 2 signatures, $6 for the one signature, $6 for the second signature, $12 total, right? Up to $12 total. Additional copies of the same document, the notary may receive $3 for each notarized signature. So you have 2 of the exact same thing coming before you. And the first original is $6 per notarial act. The second one would be $3 per notarial act on the second document. Notary may not demand and receive $3 for a photocopy made of the notarial act. So if somebody asks you to make a copy, you can make a copy. You can charge them up to $2 for that copy. Notary public may demand and receive reimbursement at the prevailing rate for mileage as established by the IRS for business travel. So we always try to keep the current rate on the notary page of our website, but you can always search IRS business travel mileage fee and find the current version there as well, or the current fee there as well. In addition to mileage, you can also charge a fee not to exceed $5 for travel if you have to travel somewhere to do a notarial act, and may not charge more than $25 for a remote notarial act. So the remote notarial acts are the ones using communication technology to appear before a notary and communicate with them. $25 for a remote notarial act. Bouncing back to the travel fees, just to elaborate on that for an extra minute here. If you're traveling, so going over travel fees, you have to travel. I have to come to somebody to notarize for them. So I'm leaving where I'm at and going to them to notarize. I can charge a fee not to exceed $5 because I'm traveling, plus mileage, plus $6 per notarial act. So $5 to travel, plus the mileage for that travel, plus the fees that you can charge up to that amount for the notarial act. So up to $5 plus mileage, up to $6 per notarial act while I'm there.
And Mike, it's a really good idea for notaries to actually identify each of the fees when they enter them in their journal, so that there's no question. If later it's challenged, it's documented right at the time it's being charged.
Exactly. Good point. Great point. You had to do the math to come up with the total, right? So you may as well note the details in your journal. Folks sometimes remember that they paid more than $6, but they may not remember why. So if you have a good note in your journal there, you'll be able to explain that. And folks often ask all kinds of questions about fees. Can I charge a convenience fee? Can I charge an after-hour fee? Can I charge this? No. Short answer is no. If you're just acting as a notary public, you're there to notarize a document. Only acting in your role as a notary public, no other role. You can only charge these fees. You can't take a tip. There's no convenience fee. There's no technology fee. There's no it's 2 a.m. fee. Nothing like that. These are the fees that a notary can charge when they're acting as a notary public. So when you're a notary, don't charge more than these fees. Notary seals and journals. Notary must furnish their own seal, right? Have your own journal. So the Secretary of State's not going to give you a notary seal. You get that on your own. But that notary seal is your property. If the notary leaves their employer, the notary, not the employer, keeps their notary seal. Why is that? That's your notary seal, right? It has your name on it. Even if your employer paid for it, even if you only became a notary because your employer said, you should become a notary, that's still your seal. It has your name on it. It is your property. Keep it with you. If you lose it, let us know. If it's missing or stolen, let us know. But keep that safe and keep that secure. It's your notary seal. It has your name on it. If it shows up on a document, it's going to show up with your name on it, not that employer's name, right? Not your friend's name, not your coworker's name. It has your name on it. It's your notary seal. Nobody else can use that but you. It should be kept in your possession. What's on that notary seal? The name of the notary public as it appears on the notary's commission. So right there, right, your name is on there, not your company, your name. The words notary public and the county in which the notary is commissioned, or if the notary is commissioned in Baltimore City, you can say City of Baltimore or Baltimore City. Can't say Baltimore City County, Baltimore County City. That's not a jurisdiction in Maryland, right? Either if you're a resident of Baltimore County and you get sworn in, you're going to go to the Baltimore County Clerk of the Court, and your seal would say your name, Notary Public, and Baltimore County. If you live in the city, your name, Notary Public, Baltimore City. I mentioned that I've had a few folks ask about that lately. Baltimore County City, that's not a place in Maryland, right? It's either Baltimore County or Baltimore City, not both. Notary's journal, a very important piece of equipment for the notary to have, must contain the record of every notarial act performed, even if the notary knows the person signing the document. We get asked a lot of questions about journals, just like fees, as you can imagine. I know the person, I notarize for them all the time. Great, still got to be an entry in that journal. Every time you notarize for them, you need to have an entry in the journal indicating that that act was performed. I know them. They're my friend. Great. Make the entry in the journal. Right? No matter whether you know them or not, whether they work for you, whether you work for them, whether you don't know them at all and you've just identified them and verify their ID and you're going to notarize for them, you've never seen them before. The time of the notarial act. Every notarial act requires an entry in your journal. And again, the law for your traditional notarial act, $6 per notarial act, $25 for remotes, but $6 for the traditional in-person notarial act. Keep your journal. It's also yours. It's your record of your notarial acts. If you leave somewhere, you take it with you. You also keep it, just like your notary seal, secure. Don't leave it sitting out on the desk. Don't leave your notary seal sitting out on your desk at work. It should go in a drawer, a locked drawer, preferably if you're keeping it in the office and not taking it with you at night. Keep it secure. We've had plenty of stories over the years where that notary seal shows up on all kinds of things that the notary never did because they didn't keep it secure. And who's the first one that gets called to answer for those things that were incorrectly done? The notary, because their name's on the seal and it's assumed that you did it. And then you would have to go explain that you didn't. So keep it secure. It's your stuff. It's your seal. It's your journal.
So Mike, I know we've had questions in the past about the seal, and you've done a great job of reviewing who is responsible for it. But I know a lot of notaries have often felt pressured by their employer, especially as they leave the employment, to leave the seal because after all, the employer paid for it. It doesn't make any difference. This is a public office. You were sworn in, you were commissioned, and that's why the seal stays with you as the notary. Under no circumstances, as Mike really already very eloquently stated, under no circumstances does it remain with the employer or in your desk as you leave employment. Yeah.
Yeah, and I know that can be a pressure, right? That is put on you. But the important thing for the notary to know, and really for the employer to know, is as a notary public, you're acting as an officer of the state of Maryland. When you put that notary hat on to notarize for somebody, you're doing it as an officer of the state of Maryland. You may also be their employee, but you're an officer of the state of Maryland. And, if you're leaving there, like I said, I can't stress that enough. Plenty of horror stories over the years of folks that left it there. 3 years later, the notary seal showing up on everything. And they're the one that has to go answer for that, even though they didn't do it. And, don't put yourself in that situation. Even if you're never going to notarize again, you leave that job and you say, I'm not going to notarize anymore. You take it with you. You got to keep your journal for 10 years anyway. It's your responsibility to keep that, right? And your notary seal, you want to, if you're never going to use it again, render it unusable, whether that's taking it apart or chopping it up or, have a bad day, smash it with a mallet. Doesn't matter, right? But that notary seal goes with you. You don't leave it with anybody, even if you don't intend to notarize beyond that point in time where you leave. It's still your seal. It still has your name on it. You still take it. You render it unusable. You make sure it never gets used again. And you keep that journal for the required time period. And we'll have some future town halls where we talk about different types of notarial acts that notaries can do and how to do those. We'll have a town hall that gives an overview of the handbook and the law and the regs, where we talk more in detail about journal entries and what's required, the notary seal and different requirements, and the general requirements of being a notary as well. So you can tune into those. And if you can't tune into those recordings will get posted online as well. The ones from last year are also on the notary page of our website. You can always check those out as well. They have all kinds of more detailed information about the stuff here, but this is the ins and outs of being a notary, how you become a notary, but also some of the important features and functions of being a notary public, which is different from being a title insurance producer or title insurance producer independent contractor. So on to that.
Thanks so much, Mike. I appreciate it. Miriam, we are ready and delighted to hear your presentation.
Thank you so much. Thank you, Mike. Thank you, Kathy. Thank you, everyone, for the opportunity. Thank you for being here this morning. I believe you'll find this information session you'll receive very useful. Please note that the presentation is provided for informational purposes only. It is not intended to be legal advice. We will discuss specific questions you may have with your trusted legal counsel or financial advisor or title producer. Today, we'll be talking about a TIPIC, and a TIPIC is a title insurance producer, an independent contractor. Next slide, please. Yeah, I just mentioned that. It's thank you, Mike. This presentation today will attempt to help those who do not know exactly or who need a reminder or clarification on who a TIPIC is and who a TIP is. I believe both needs to be clarified as well, and who they are not. Some may already know what some of you may need clarification on specific requirements for obtaining, maintaining, and renewing a license as a TIP or a TIPIC, appointment as a TIPIC and a TIP, the bonds requirement. We'll also be talking about misrepresentation by individuals who do not have the required license to engage in providing settlement service as a TIPIC. And hopefully this session will help in providing you with that useful information and guide you to be compliant with the laws. Let's get into it then. Next slide, please. So who is a TIPIC? A TIPIC, some of you may already know who that is, who a TIPIC is, and some of you are already TIPICs or a TIP. The insurance article specifically provides for who a TIPIC is. A TIPIC is a title insurance producer, while a TIPIC is a title insurance producer independent contractor, both are licensed to act as title insurance producers. They provide escrow services, they provide closing settlement services that may result in the issuance of title insurance. A TIPIC provides the same, both the TIPIC and a TIP. The TIPIC does so on behalf of the appointed title insurance producer. Please also note that the insurance article makes it clear that a TIPIC is not an employee of the licensed and appointed TIP, but a contractor settlements provider. Let's talk more about the TIP and the TIPIC. Thank you. So let me clarify on who a TIP is and then who a TIPIC is, just so that we understand that the differences as well. That would help us, especially when we come to, when any of you want to put in an application to either be a TIPIC or a TIP. Let me explain who a TIP is. A TIP is a person who would also be a title company, or an attorney who solicits, procures, or negotiates title insurance contract for compensation, or who provides escrow closing and settlement services that may result in the issuance of title insurance contract. While a TIPIC, on the other hand, can be an individual or also an attorney, but not a company, who solicits, procures, negotiates title insurance contract for compensation, or who provides escrow closing or settlement services that may result in the issuance of title insurance contract or policy. Please also note here that those who may not know or are unaware or need clarification, a TIPIC may also be a commissioned notary in order to witness, document, or conduct other notarial acts. Let's be clear on that. A notary is not automatically a TIPIC. There are requirements for that. A TIPIC should not assume or conduct notarial acts if a TIPIC is not commissioned as a notary. It could be a violation of the law and liable to appropriate sanctions to do so. Next slide, please. So let's talk about the difference now. We touched on that, the difference in the previous slide between a TIP and a TIPIC. Please also note that a TIP is not a notary either, without being commissioned as a notary. A TIPIC contracts to provide settlement services for a specific, or in some cases, a number of settlements with a TIP. A TIPIC is not an employee, but a contractor of a TIP, like we mentioned earlier. A TIP, sorry, give me a moment, please. Thank you. To be a licensed TIP or TIPIC, there are specific requirements. Let's try to consider that. Next slide, please. An individual who wants to engage in providing settlement service as a TIPIC is required to obtain the title producer license. Both the TIPIC and the TIP must be licensed by the insurance commissioner to conduct business in Maryland. And to apply for this license, an applicant needs to, an individual applicant must complete the application, submit it along with an affidavit indicating which whether the individual applicant is to be a TIP or a TIPIC. A background check is also a requirement of this application. Background check will be conducted in the process of in trying to process the application. And in addition to the license requirement, there's also a pre-licensing class that all resident applicants applying for a license, applying to be licensed as a TIPIC or a TIP required to attend and pass the exams conducted after the class. Please see the link below for additional information on how to go about doing that. And also information about available vendors for those classes and exams. Let's move along. Next slide, please. Here are some additional information about the licensing requirements in order to secure a license. So in addition to passing the exam, a licensed applicant is required to complete and submit the application with the required statutory application fee of $54. A 150 surety bond or letter of credit is also required. The bond certificate must, on the face of it, clearly states the bond company, the amount, the coverage period, and also indicating that the state of Maryland is the obligee for that. Those are some of the additional requirements of any person who desires or wishes or want to obtain a license. And after obtaining the license, an individual licensee would also need to be appointed by an insurance underwriter. I've received a lot of questions about that, and hopefully this next slide would help clarify that. Next slide, please. Let's talk more about this requirement for an appointment. The responsibility for this appointment, and I hope this will help answer your question, the insurance article places joint responsibility on the TIP, which is usually the title company, the TIPIC, that's the independent contractor, and the underwriter, to ensure that the appropriate appointment are granted and also verified and established before a title producer, as a TIPIC, whether a TIPIC or a title insurance producer procures or negotiate title contract for compensation. I've received a lot of questions actually about that. So let's just clarify that again. The responsibility of obtaining those appointments are on the TIPIC, the TIP, and the underwriter. All parties involved must ensure that everyone that is involved is, obtains the required license, maintains those license, and also maintain those appointments during the course of whatever transaction, as a TIPIC or a TIP. A TIPIC is also responsible for ensuring that the TIPIC for which he or she enters into a settlement contract with is licensed with the specific underwriter in question. Let's move along. Let's talk a little bit more about the bonds requirement as well. The TIP, in this case, a title company, is required by the insurance article, in addition to obtaining a license, obtain and file with the commissioner blanket surety, fidelity and surety bond or letter of credit. The TIP is also required to maintain those bonds and provide renewal certificate when renewing the license. It is a responsibility of the TIP, it is the responsibility of the TIP to maintain the bonds, and it is the responsibility of the insurer as well and the TIPIC to ensure that the TIP has those bonds, and it is clearly a violation for a TIP to use a TIPIC unless the TIP has a bond that covers the TIPIC. Let me say that again, because I've received questions on that. It is a responsibility of the TIP to ensure that he maintains bonds the fidelity and surety bond, and that bond covers the TIPIC for that specific contract of settlements being entered into, except of course the TIPIC also maintains a separate bond, but in most cases a TIPIC a TIP should maintain those bonds and covers the actions of the TIPIC for that transaction. The TIP, being the legal principle of the TIPIC, is liable for all acts conducted by the TIPIC if such acts are done within the scope of the TIPIC's contract with the TIP. So it is a responsibility of the TIP to ensure he or she has bonds. The title company has bond that covers the TIP, except the TIP maintains a separate bond. I hope that answers your question on that. Next slide, please. So, enforcement actions. Yes, there are consequences for some of those violations. The laws are there to ensure order. Everyone who seeks to engage in settlement services is required to ensure that the required license is obtained. Talking about the violations of the insurance article, there are a number of enforcement actions that can be taken against an individual or company that is found to be in violation of the law. It is the violation of the Maryland law for individuals or company who do not possess the requisite license, title producer license, to represent or conduct title business as licensed individuals or company, or carry out settlement services without first obtaining the appropriate license, either as a TIPIC, in this case, an individual or title company, or as a TIPIC, and maintains a bond or letter of credit. Please note that a violation of the insurance article for a person who is not a duly licensed TIPIC to make a representation that the person is a TIPIC. If you are a TIPIC, you're a TIPIC. You're a notary, you're a notary. If a TIPIC decides to conduct settlement services, if a TIPIC decides to conduct notarial acts, that TIPIC is required to be commissioned. If a notary decides he or she wants to conduct settlement services, there is a requirement for that as well, obtain the TIPIC license. So a notary should not represent him or herself as a TIPIC when not licensed. Neither should a TIPIC represent he or herself as a notary. So let's take note of that. A TIPIC or a TIPIC who violate the insurance article may have their license revoked or suspended. There could be also financial penalty that may be imposed, and they may be required to make restitution to anyone who has suffered a loss as a result of that violation. There are definitely other resources that will be provided on that link regarding that. And of course, if you have any further questions on that, feel free to ask during the question sessions. Thank you so much for listening, and I hope that a lot of your questions have been answered. Please make reference to the links provided and as part of this presentation.
Thanks so much, Miriam.
Thank you.
I'm grateful.
Thank you.
Carrie Ann, I know you've been monitoring the chat box. Do you have any questions for us that are in there for our speakers?
Is it okay to ask a question, or do I need to type it?
Well, if you don't mind to raise your hand, we're going to go to the questions that are in the chat box first, and we'll certainly get to you. So, Carrie Ann?
Sorry, I was a little lagged here. I kept getting interrupted, and with every time somebody tried to get in, it stops me from typing. So the first question I have that I hadn't been able to answer yet is from Janice Parker. She says, hello, I'm retiring in 2023. What notification is required on retirement? Please confirm statement that my home address and phone number becomes public record.
Yep. So yeah, well, first, congratulations on your retirement. If you retire from your employer, or if you retired unemployed, and stay a notary public, your home address and home phone number are public information. If you do not have a business address and business phone number, we don't post the home address and home phone on our website. Somebody would have to specifically ask us for that info. But if you don't have a business address, your home address is public info. If you don't have a business phone, your home phone would then be public info.
Thanks, Mike. Carrie Ann, is there another question?
There is. I have it from Lori. I worked at an employer a few years ago and was asked to notarize a document unlawfully. It was already signed by the customer. I refused, and I was told that the corporate office would notarize it. I was wondering if I should have reported the suspected notary fraud or what.
I mean, if you felt the need to, I understand the delicate balance you have there, right? With your employer and your role. If you ever did reach out to us about the Notarial Act, we wouldn't disclose who the complaint came from. So we wouldn't have put that out to anybody. We would have just asked about the specific act that was done incorrectly. Although I imagine it probably would have been easy for somebody to figure out who said something, because they, so it's a delicate balance. It's a hard question to answer. But if somebody were to reach out to us, we would certainly look into that and take appropriate action. But we also wouldn't disclose who it was that made the complaint, to try to offer that layer of protection there.
And to answer the question, there is the notary's obligation to witness the signature. So I think that's really the core of the question that's being asked. So if that didn't happen, that is a violation that you could report, of course.
I guess my main question was I obligated to report what I knew was going to be, what I learned was common practice in that corporation. And I left that employment partly because of that. But was it my obligation as a notary to report this fraudulent activity that apparently was ongoing?
Well, there's nothing in the notary law that says you have to do that. But, we like to know those things so we can deal with the situation.
Yeah, and sometimes the notaries or employers simply don't know. And so it's an opportunity for us to also educate them. And so had we been advised, we certainly would have taken the initiative to, as Mike said, investigate, but also to educate.
Yep.
So thanks. Great questions. Carrie Ann, do you have another question?
Yes. Allison Bishop. What are the requirements for the notary to become a TIPIC? I tried to do this 5 years ago and I was told I could not do it in the state of Maryland.
So I think, Mary, I'm going to toss that to you. I think you just reviewed those requirements. Perhaps that's a good thing to do, to have a conversation with this individual offline.
Definitely, I'll be available. I don't know, do I provide my email address to discuss it?
Mike, if you can move back to the slide with the Maryland Insurance Administration's contact information, please.
Yep, right there. Reach out to MIA.
Yes.
Okay, great questions. Thank you. Carrie Ann, another one?
Brenda Wade said she's still confused as to the differences, particularly as it relates to a notary public.
The differences between a notary public and a TIPIC, Brenda? Brenda, are you on the call?
I am. Good morning.
Good morning.
No, at the time when we were going through it, the TIPIC, because I'm new, and I think someone in the chat asked if there was an opportunity for those of us that are kind of new to this to maybe come together and just to better understand the process. But my question was, it was just moving pretty fast for me and I was trying to take notes, I'm a notary public now. Once I take the course and pass the exam, I can then become a TIPIC, not a TIP. Is that correct? the TIP is the actual title insurance company? Or an
So-
individual
I'll
that's,
pass that question to you.
Yes, so the TIP is both a title company and an individual. So a TIP can either be a title company or an individual.
Okay.
The main difference really is in the application. If you want to be a TIPIC or a TIP, there's usually an affidavit that you need to complete with your application indicating that you want to be a TIPIC and not a TIP. I think I made mention of that in my presentation. You can have a look at that again. Yeah.
yeah, it just seemed like in order to be, for those of us that are notary publics, that would just make sense that we would be TIPICs and not TIPs.
Right. And I think now, a TIP also needs to be a notary as well. A notary needs to be a TIPIC in order to conduct settlement services.
And yeah, as far as and moving quickly too, we'll have this recording posted online here within a few days.
Okay.
So if this was moving quick for anybody, you go back and watch it at your own leisure and time, and you can slow it down and kind of re-listen to areas. But this will be posted on the Secretary of State's website, on the notary page, within a few days.
Good point, Mike. It'll be the presentation only that
Mhm.
is posted.
Yep.
Okay. Carrie Ann, do you have another question in there?
I do. Simon asks, in a notary public, do acts for a deed or mortgage documents?
Oy.
Well, it sounds as if, Simon, are you on the call still?
Yes, can you hear me?
Yes.
Okay, yeah. Well, in some situations where there's not any funds exchange, I've noticed that where I work at, we've had few customers come in with like a deed document where it just wants us to notarize the person who's signing, but no money exchange sort of thing.
So Miriam, this may be a question for you because it sounds as if, and Simon, please correct me.
Sorry, I apologize. Can you hear again? Can you say your question again?
Yes, in situations where we have customers come in with deeds or like mortgage statements, or not really a settlement, but just that the mortgage company needed somebody to verify who's signing, but no money is being exchanged. Like it's not an actual sale.
Right. It's just for you to acknowledge the signatures, to witness the signatures.
Yes. So we had some not really clear direction on it. So I just wanted to put it out there to see what.
I will need to get back to you on that just to be sure. I don't want to say I don't want to misguide you regarding that. I know that if as a notary you can witness signatures, but with regards to signing a deed that there is no money exchange, I will need to get back to you on that.
Okay.
Yeah.
And Simon, perhaps you can reach out, Mike, if you put that contact information up one more time, please, for Maryland. There you go.
Yeah.
If you reach out to the Maryland Insurance Administration at the contact information displayed on the screen, it'll be easier for them to reach out to you.
All right, great. Thank you.
Great. Thanks so much. Carrie Ann, do you have another question?
Yes. Kay Henderson wants to know if we're going to share this presentation.
Well, yes, we
We just went over it.
Yep. Okay. The presentation will be posted on the notary website.
All right. And this one's Chaplain said, can you explain the bond again?
Miriam?
Okay, let me, I guess, explain what is it the bonds requirement? I apologize.
Chaplain, are you still on the call?
I am.
Okay, perhaps you can explain the question for Miriam.
Okay.
Chaplain, if you explain your question, please, we'll be able to respond.
Yes, please. Thank you.
Okay, I just really wanted to know the requirements for the bond and what basically is the bond.
the TIP, which is a title insurance producer, is required to maintain a blanket fidelity and surety bond or a letter of credit for the transaction for which a TIPIC is contracted to conduct for the TIP. That bond is going to cover the acts of the TIPIC for that transaction or other transactions. If a TIP does not maintain that bond, or a TIPIC in some cases can maintain also a separate bond. Does that answer your question?
Yes.
Okay.
Great, thanks so much. Carrie Ann, is there another question there?
There is. Someone wants to know if they'd be able to shadow a TIPIC.
Miriam, I'll punt that question to you, but I think that's beyond the scope of what we regulate.
Yes, a TIPIC
as well, right?
is either you're licensed to conduct settlement closings or you're not. There is no shadowing. You need to obtain the required license in order to conduct your business as a TIPIC.
Thank you, Miriam. Carrie Ann, is there another question?
So Sonia would like to know, can you explain the difference between a TIP and a TIPIC in plain English? And how do you find a title insurance company to work with?
The difference between a TIP and a TIPIC. I think to just kind of clarify, a TIP conducts settlement closing just like a TIPIC. The licensing requirement is also the same. The difference now is the fact that a TIPIC is not an employee of a TIP. So I think there's sometimes there might be confusion about who is a TIP when you're talking about an individual and who is a title company. Is a title company also a TIP? Yes. A TIP can either be an individual or a title company. But a TIPIC is different because an independent contractor, he's not an employee of a TIP. He conducts settlements. The TIP usually contract the TIPIC to conduct specific closings or a number of closings. Usually the TIPIC enters into a contract with a TIP to conduct settlement closings. So I don't know if that responds to your question. And in terms of the licensing requirement, is pretty much the same. It's just that when you're applying, you will need to indicate whether you want to apply as for the license as a TIP or a TIPIC. I don't know if that answers your question.
So that answer the question of the person who asked? In the absence of a response, we'll assume it does. Okay, Carrie Ann,
Can I ask a quick question?
we'll get to any other questions in order, okay?
Miss Kathleen?
Good. Carrie Ann, remind me, please, who asked that last question?
That would be Sonia.
So Sonia, are you still on the call? And if so, did that response satisfy your question?
She said it does.
Okay, that sounds great. Carrie Ann, is there another question in there?
Yes. Katrina asked, is there a course specifically for Maryland notaries after receiving a TIPIC license who want to do real estate signings as a notary signing agent? In other words, any courses to go over real estate documents specific to Maryland that need to be signed or notarized? How do you conduct signings? Thank you.
Miriam, is that something the Maryland Insurance Administration conducts? That certainly is beyond the scope of what the Office of Secretary of State is able to do.
Right. You know, when you apply for the application for the license, there's also a pre-licensing class that you need to take. Those pre-licensing class give you information on how to conduct closings. I don't know if that answers your question. And it goes over real estate documents as well. So you get to familiarize yourself with all that.
Oh, that's great. Perfect. Thanks, Marianne. Marianne, we have a couple of hands that are raised. Before we get to them, are there any other questions in the chat box?
Yes, there's a few.
Okay.
It doesn't sound like a TIPIC is really an independent contractor. Are they carrying workman's compensation insurance, or can they be found to be an employee of a TIP? I'm not quite understanding the question.
Mike, if you go back to the slide of differentiation, please. And Marianne, I'll put the question to you since it's a first administration question.
Yeah. A TIPIC is not an employee of a TIP. I think that's one of the main differences between a TIP and a TIPIC. About obtaining a worker's insurance, I'm not sure how to respond to that because I don't quite understand that. But a TIPIC is not an employee of a TIP.
So perhaps, Carrie, in the name of the person, please, who asked that question.
Stacy, I'm sorry.
So Stacy, Mike, if you go back to the slide, please, with the contact information for the Maryland Insurance Administration. Sounds like that's a good question to follow up with the Maryland Insurance Administration offline. Okay. Thank you. Carrie, any other questions?
It's Pamela Martin. She says, what if you are a notary, a certified notary signing agent? I'm not sure what she's asking. That's Pamela Martin.
Pamela Martin, are you on the call? Pamela Martin, are you on the call? We'd be happy to get clarification from you if you are. I guess she's going to have to follow up with the Maryland Insurance Administration. Any other questions?
Yep. Sandra Campbell, I witnessed a UPS person notarizing a loan document that was not a TIPIC. Is this okay?
Marianne?
So sorry, can you ask that again?
I witnessed a UPS person notarizing a loan document. Was that not, if he was not a TIPIC, is that okay?
A person who signs document as a TIPIC group is required to be licensed. If a person does so, that might be a violation of the law.
There you go. Thank you. Okay, Carrie Ann, next question.
Bob Fairfield, that kind of off topic, is the fee for notaries set to increase at any time? If not, what do we need to do as notaries to get it increased?
The fees for notaries, the fee, you mean that the notary can charge, is that correct?
Yes.
Yeah. The fees just increased recently and they were on part of the presentation that Mike Schlein gave. So as you review the presentation, you'll be able to see what those current fees are. Okay. Thank you. Mike, if you want to recite them really fast for this person, you're welcome to do that.
Yeah, sure. Slide back up to the fees page. $6 per notarial act. These fees changed in November of 2022. So it used to be $4. It went up to $6 just a couple months ago. The $3 and $2 fees are an increase from, I believe they both used to be $1. The IRS mileage rate changes as the IRS changes the business travel mileage rate. So that's flexible with time. So if the IRS increases the mileage rate, then the amount that a notary can charge for traveling will increase by that mileage rate. So as the IRS changes that amount changes. So that's a flexible number. The $5 to travel. So again, that's $5 plus mileage plus notarial act fees. But these fees all for notaries just changed in November. And the remote notary fee used to be $4 across the board for every notarial act. The remote notary fee is now $25 which allows people to cover those costs of, the technology required to be a remote notary.
Right.
So $25 for Remote Notarial Act now, as opposed to $4 back in the beginning of November. So all those fees just changed, I guess, about 3 months ago.
Yes. Thank you so much. Okay. Carrie Ann, any other questions? Excuse me. And then we'll have a few folks whose hands raised. We're after our time, but we're happy to stay on to answer some more questions for a short while more.
Okay. This one is just, it's MGR. A person who is a licensed title producer, comma, notary public, also provides services for will and trust. Can he notarize the will and trust documents?
So MGR, you actually are on the screen now. You had a question earlier. Is this the same question you had earlier?
Yes.
So just to summarize, your question is, can you as a notary notarize a will and trust document? Is that the essence of your question? That changed with the law that Mike just referred to. So yes.
So we can do that, right?
Yes.
Okay, thank you.
That has nothing to do with title insurance producers. Yeah.
Okay.
Okay.
Shannon Neal, is there a list of documents that notary publics can notarize as it relates to real estate? For instance, a loan modification.
Mary Ann, is that something the Maryland Insurance Administration has?
I'm sorry, can you repeat the question again?
Is there a list of documents that the notary public can notarize as related to real estate? For instance, a loan modification.
Is it as a notary or as a tip?
I think they're asking it sounds like they're asking if they're just a notary and not a tip, if they can do any type of loan documents. Like if it was a loan modification, would they be able to do that?
No. So if a notary wants to conduct, review, sign, and conduct a loan modification, the person needs to be licensed to do that.
Thank you, Carrie. The person who asked the question, did that satisfy your answer?
I was wondering if there is a list of resources that, or if there's a document that says kind of a comparison of what a notary public can notarize versus a TIPIC. In my industry, we do see a lot of loan modifications and real estate documents. My company has given us some somewhat conflicting information saying that as long as there's not a title or monetary transaction with it, that it is allowable. So I'm just really trying to clarify, because it really sounds like you need to be a TIPIC to do any of these things, but some of the information that we're being provided or things we're being asked to do is in conflict with that.
So it sounds like you may be best off reaching out again directly to the Maryland Insurance Administration.
Yes, and then we'll be able to respond to your question in detail.
Okay, thank you.
Thank you.
Happy to help. Carrie Ann, any other questions, final questions?
All right, this is a notary question. Brenda Wade, if we're commissioned in County A, and now I live in County B, at the time of my renewal, do I need to renew in County A or renew in County B?
Well, so if you lived in County A and you moved to County B, and you now live in County B, when you renew, if you're still living in County B, you will get commissioned in County A. And you'll have to get a new notary seal with that county's name on it. So yes, you'll get commissioned in County B this next time when you renew, because that's where you live at that time. One difference I want to point out, because it is a question we get asked sometimes. If you're commissioned as a notary, say I got sworn in Baltimore City, I'm a notary in Baltimore City. That's where I lived when I applied. That's where I lived when I got commissioned. I'm a Baltimore City notary for these 4 years. 2 years in, I moved to Anne Arundel County. I don't have to get a new seal. I'm finished at that moment. I don't get a new seal. I'm still a Baltimore City notary because that's where I was sworn in. Changing your address doesn't require you to get a new commission. So when I renew, I live in Anne Arundel County. I will now renew and I'll become an Anne Arundel County notary and I'll get sworn in at the Anne Arundel County Courthouse. And that's when I'll get my new seal. The next time I get sworn in and I have an updated seal with my updated county is the next time that, or next time I get sworn in will be when I get my updated commission, which will require me to get my updated seal.
Thanks, Mike. Carrie Ann, any other questions?
Can you be a TIPIC without a notary commission? That's from Sheila Brady.
Miriam, this question is for you.
I think all TIPICs are required to be notaries as well. There's a change in the law regarding that. So every TIPIC needs to be a notary as well.
I just moved back to the slide where it talks about that as well. So I'll just leave that up for a second as well. TIPIC must be commissioned notary.
In order to witness documents, yes.
Thank you. Perfect. Okay, Carrie Ann, any other questions?
This one is from Brittany Butler. It says, I am a TIPIC. My question is, does the stamp and the raised seal need to be on all documents, or can the stamp that looks like the seal be significant or sufficient? I'm sorry.
Is it the TIPIC stamp or the notary
Hold
stamp?
on. So I have the raised seal stamp and I actually have the actual just stamp. My question is, do I have to use the raised seal stamp every time I stamp, or do I get a stamp that looks like the raised seal and stamp it? Like, is that sufficient or do I need both?
TIPIC stamp or notary stamp, though? Which one are you asking about? The TIPIC seal or notary seal?
So I'm a notary and a TIPIC. So I use, there's a difference in stamps. I wasn't sure.
Well, I'll answer specifically for your notary seal. It doesn't matter if it's the raised paper mark or the ink stamp. They both are valid. As long as they have name, county, and the words notary public. So whether it's the one that's the embosser that makes the raised paper marks or the ink stamp, they're both legally sufficient as a notary seal. But I don't know about the TIPIC.
Miriam, can you speak about the TIPIC seal? Yes.
Yes. For a TIPIC, the information of the TIPIC is required to be on the documents that has been signed, the deed of trust, the mortgage. But a TIPIC does not really have a stamp, does not have a stamp. They just need the information provided on the document that is being signed. Yes.
Cool.
Thanks, Miriam.
Yeah.
Carrie Ann, another question.
Jennifer Spalding, is there a separate application to become a remote notary public?
Yes, there is. On the notary page, sos.maryland.gov, sos.maryland.gov, click on notaries, and there'll be 2 remote notary forms, actually. One for remote notarizations regarding tangible records, and one for remote notarizations on electronic records that require a very specific type of remote online notary vendor to perform. So they're not an application per se. It's called a remote notary notification form. Once you're a notary, so you applied to become a notary, you were approved to become a notary, you got to the courthouse within 30 days, you took the oath of office, now you're a notary. Once you're a notary, you can send us a form to notify us that you intend to perform remote notarial acts. And but there's 2 different forms, one for electronic records, one for remotes on tangible records, because they're distinctly different things. And you'll need to complete that form, send it to us, follow the instructions on the form about emailing it to us. And then when you hear back from us with the approval, then you're authorized to perform remote notarial acts at that point. But you'll have to send it to us and get the confirmation from us by email that says you're authorized.
Okay.
And
So
there will be a town hall in the fall specifically on remote notarization. So keep your eyes out for that.
Okay. And then, because like I said, I'm technically now I am a licensed notary through the state of Maryland. So I would just need to go on their website and fill out that application and proceed forward.
That's right.
Yep.
Okay, thank you.
Of course. Carrie Ann, there's another question in there.
Allison Bishop wrote, I took a closing class 5 years ago. Can I use that class? It was not through the state of Maryland. However, I have been commissioned notary for some years now.
Allison, you want to use that class for what purpose? We don't want to assume what you're asking, so if you can clarify, please, if you're still on the call.
Yes, I'm still here. I was trying to find out if that class would qualify as the pre-licensing class that I think Miriam talked about in order to become a TIPIC.
Okay, so
Because when I took the class some years ago, they basically said that all you have to do is have this class and you'll be able to notarize closing docs. Then when I got talk with the people in the state of Maryland, they said, no, you can't notarize any closing docs because you don't have that insurance license. So I, in essence, thought that what they were doing in other states, we had the ability to do here in Maryland, and that was not the case. So I did pay for the class. I still have the knowledge from the class. So that's why I was just asking about would that qualify for the pre-licensing?
Miriam, that's a question for you. We'll invite you to answer it, please.
I mean, if you took the exams a long time ago, you need to take another exam. It's been a while, especially because even TIPICs are required to take CE, continuing education. In order to obtain the license, you need to take the classes and sit for the exam and pass for you to be able to get a license.
Okay.
Great, thank you. Appreciate that.
Yes, thank you.
No problem.
Carrie Ann, is there another question?
This one is from Lucy. She wants to know, does it matter if I notarize for someone living in Montgomery County, even though I was sworn in PG County? Can I notarize anywhere in the state of Maryland?
Yes. Yes. As long as you're in the state of Maryland, you can notarize.
Yeah, Mike, let me just add to the previous question. I don't know if that's okay.
Absolutely.
Yeah, so I know she mentioned she took the classes a long time ago. She will need to confirm that those classes are approved, because I don't think all classes are approved. They're approved classes to take, and the exams as well. So please take note of that.
Thanks, Miriam. That's good clarification. So hopefully Bishop Allison is still on and she's heard that response.
I wanted to say something, that if I'm allowed to make a comment.
This Lucy, your question you just had, so go ahead. Yes.
Yes, I just wanted to say, because I've been a notary for some time, and I am in the middle of taking a class for the TIPIC. And I just wanted to say something that I know a lot of people are asking some redundant questions, and just to clarify. And I know that you guys have explained and have the term, you guys have what it means, the difference between TIP and TIPIC. A lot of the confusion was in the beginning for me, and this is just, if this helps anyone, is that Maryland, and there's one other state in all of the United States that is required to take a course and have a title insurance producer license. A lot of times we look at what other people are doing in other states, and those requirements that they have in their state is not the same requirements we have in our state. So in the state of Maryland, we're like the only one in the whole United States that is required to get your license as a title insurance producer. Whether you want to work at a title insurance firm, and you're going to be conducting this type of work, you have to be licensed. However, that facility, that office will have their own errors in the mission, their own bond insurance to protect their entity. If you're going to be working in their office, you're going to be independent, then you need to have your own bond, your own errors and omissions to protect yourself. Unless you are hired, like if someone calls you from Baltimore, who's a title company, and you're in, I don't know, and Charles County or something, somewhere in, or let's say PG County, which is far away, and you are on a list of people who have the license, they can contact you so that you can do those transactions on their behalf. And so if it goes that way, then you'll be under them, as far as protected under them, because you're doing the services through them to do that transaction on their behalf. So again, if you're listening to someone in Atlanta, you listen to someone in Florida or any other state, their requirements are way different. They are not required to be a title insurance producer. So listening to other people in other states can be very confusing. And so title insurance producer is the same as a signing agent, so that there's no confusion. AKA signing agent is a title insurance producer for the state of Maryland.
So Lucy, thank you for your comments. I think it's always good advice to remember.
Thank you.
In the state of Maryland, you need to follow our state laws. So whether it's for a notary public or TIP or TIPIC, please contact the regulating authority, that is the Maryland Insurance Administration for TIP and TIPIC, and the Office of the Secretary of State for notaries, and they can give you the accurate information and direct you appropriately. Carrie Ann, is there another question?
A couple of them that I answered in there, so I hope they're still on there. And I think most of them are like repeat questions, so I think we've pretty much got them covered. I did put a note in the chat box if we didn't get your notary question answered to please email us. I put our notary email in there, so
Thanks.
any questions can be there.
Thanks, Carrie. And so we're just about a half hour beyond the allotted time, but we have a couple of hands that are raised. So let's see if these questions have their questions have been raised so far. Natasha, are you still on, and do you still have a question? Natasha Nesmith, are you still on, and do you still have a question? You may be on mute, so I'll give you another minute if you're still on to unmute yourself. So I'm happy to hear your question if you have one. In the absence of response, Katrina Harris, are you still on?
I'm sorry, it wouldn't let me unmute.
Oh, there you go, Natasha.
Hello, everyone. My question is, when I took the title insurance agent class, it told me that it was for the title producing company, which made it confusing when they told me I had to take the TIPIC as well. What's the difference in the agents? Is that just a more experienced notary public?
So, Mike, you want to put that page up in and then very well understand, but you put the page up, can't they tell the difference between the TIPIC?
Sorry, there was an echo at the background, so I didn't quite get the question. Let me just repeat it to see if I got you. I think you were trying to find out if there's a difference between the requirement, the requirement to take the classes for a TIPIC and a TIP separate requirements. Yeah. Was that your question?
Natasha, the question is to you.
I know they're separate now, but in the beginning, when I took the title agent class, it was indicating that it was for the TIPIC, because if I'd have known that it was for just an agent and not TIPIC, I would have never taken the agent class. I would have just taken the TIPIC class.
What? I'm not aware that there's really. I know that not all those classes. The MI those courses and those for TIP and the difference is in the application of the class.
Okay.
Does that answer your?
No, because like I said, it was really confusing.
Okay.
So Natasha,
When I started out.
you reach out directly to the Maryland Insurance Administration.
Okay.
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 Thank you.
Thank you.
Katrina Harris, are you still on, and do you still have a question?
Yes, I do. Some were answered, but I still have two. With regards, I am a notary in the state of Maryland. So since we are kind of in a tri-state where we're bordering Virginia and DC, would I have to get an additional notary certificate to notarize in those states, or can I notarize for DC and Virginia?
So as a Maryland notary, you are only commissioned to notarize within the state of Maryland. You cannot be outside of Maryland. You cannot use your Maryland notary seal while you're standing in DC or Virginia. If you want to notarize in DC, you need to go get a DC notary commission. If you want to notarize in Virginia, you need to become a Virginia notary. There's not a reciprocity in the sense that if you're a Maryland notary, you can just become one for Virginia or DC. You have to apply separately with DC. You have to apply separately with Virginia. You can only use your Maryland notary seal if you're inside of the state of Maryland.
And DC and Virginia will be able to tell you what their specific requirements are for their jurisdictions.
Okay. Now, my second question is with regards to the TIPIC, what are the fees that you could charge for TIPIC services? I don't know if that was covered, but
no, that wasn't covered because it varies, right, per transaction. So there's no fixed fee that you charge. It varies per transaction. I think that each transaction will determine how much fees.
So you may want to reach out directly to the Maryland Insurance Administration for those specific transactions.
Yeah.
Okay.
All right. So I think those were my two. Thank you.
Thank you. Angelic Jenkins, your hand is up. Are you still on, and do you still have a question?
Yes, I'm still on, and I do have the question. I'm just going to kind of piggyback on Miss Lucy, where she said in Maryland, you have to be a title producer to actually witness a closing or a refinance, which I understand. But if someone calls you to contract to do a closing because it's up the street from you, and you ask them, will their insurance cover you? And they say no, are they required to cover you? I mean, if you don't have, the insurance, are they required to cover you? Because I know we can have our own, but are they required? Because I know they should, and most of them, 90% of them, they say yes, we'll cover you. But I've had a couple that say no.
Yeah.
So we don't cover you, not insuring for you to do. You'll have to.
Yeah, there's actually
no. Go ahead.
Sorry. Okay, there's actually one of the slides that I talked about that. It is the TIPIC. The TIP is required to provide a blanket surety and fidelity bond that covers your actions, whatever acts you do within the contract that you are that you signed to conduct that settlement for the TIP. So it is a requirement for the TIPIC the TIP to make sure that you're covered. The TIP maintains that bond, and then the bond covers you for that transaction that is being conducted. Some TIPICs do have the separate bond, but if the TIPIC doesn't, it is the TIP is required to maintain those bonds, and that is required those bonds should cover your actions for the TIP.
Okay. Yeah. Thank you. I do have mine. But some of them did and some of them didn't. I just want to know, are they required? And I have a second question. Oh, go ahead.
No, I'm just saying yes, they're required to. So go ahead with your question.
Oh, so they are required, but I know we have ours, but they are required to have the insurance if they actually contract you.
Yes.
That is correct. Okay. All right, so that answered my second question is going back to when we spoke about notarizing in DC and Virginia. We cannot notarize in that territory, but if the DC or Virginia person comes into Maryland, we can notarize their paperwork. Is that true?
Yes.
Yes.
It matters where you are standing as a notary. You're commissioned as a notary in Maryland, so your jurisdiction begins and ends in Maryland. So as long as you're in Maryland when you're notarizing, it doesn't matter where that person came from or where that document's from or going. What has to happen is you have to be in Maryland when you're notarizing.
Okay, I just want to make that clear that they can say, hey, you have come over to my office in Maryland. I cannot come to you. Okay. All right. Thank you very
You're welcome.
much.
Drew and Evelyn, Christopher, are you still on, and do you still have a question? Derwin, Evelyn, Christopher,
Yeah, sorry,
are you
I'm
still
sorry,
on?
I'm on Darwin.
There you go.
Yeah, my question is, I'm a notary coming out of, someone asked earlier about signing a deed where there's no financial transaction. So my question is that once I issue a notary certificate, would that be the type of action or the type of work I did at that point in time?
The notarial certificate indicates the type of notarial act you performed. So was it an acknowledgement? Was it an oath or affirmation? Was it an official witness? Was it a copy? It's specific to the type of notarial act, not so much the document you performed it on or that it was performed for. So if it's an oath, it's indicating that you identified the signer, you watched them sign, they swore to the truth of the document in some way, shape, or form. If it was an acknowledgement, the certificate is indicating that the person acknowledged that by signing this constitutes their act of deed. So the certificate is saying what you as a notary are doing for that individual who's executing that document. But regardless of what type of document it is that you're notarizing.
Well, so the bottom line is that based on what my certificate would indicate would be that type of document signed.
No, the certificate does not indicate the type of document. It indicates the type of notarial act.
Material act, yeah, the material act, yeah, that's what I meant, right.
Yep.
Okay, thank you.
Okay. We have 3 more hands that are raised. So we'll go to Rudy Ektish. Are you still on, and do you still have a question? Rudy Ektish, are you still on, and do you still have a question?
Sorry, I was muted. Sorry, I was muted. Are you going to issue notary numbers to notaries? Are notaries going to be my notary number is so and so, or is that not something that Maryland is going to do?
Maryland doesn't have a notary or commission number. That ID number that you use that you have isn't your notary number. It's just a number you use in terms of verifying who you are when you try to renew or update your information in the system. There's no notary number that needs to go on a notarial act. So I know some states have notary numbers, notary ID numbers, and the number has to be on the seal or in the certificate. That's not the case in Maryland. Maryland does not have a notary number. There's no number that should go on your seal or be noted on any document when you notarize. Just your expiration date, right? That's the only number you're really putting on there.
Correct.
Are there going to other plans to do that? Because occasionally I'm being asked about it.
Well, the other states that require that, you just let them know that Maryland doesn't have that, you can't give them a number that doesn't exist, right? So, we've never had one. Not aware of us going to one, but you don't have what you don't have, right?
Right. Okay. Just wanted to know. Thank you.
Thank you. Marlene, are you still on, and do you still have a question?
Yes, and it was more so a comment than a question, like Lucy had stated before. One of the issues that I've come across is where people tend to get things mixed up with other states, and some of it has to do with NNA as well. Whereas I'm certified signing agent, according to their standards, but we still have to fulfill those Maryland standards. So, you know, my website that I'm building, it doesn't have anything about me being a TIPIC. I have business cards about me being a notary public, but it's not about TIPIC because I have not taken that license exam yet. So, you know, we have to be really careful with the information and making certain that it's specific to, you know, to Maryland. The NNA, like I said, you know, they issued a certificate. I took the exam. I, you know, did all the coursework and everything else. But I know because of research that, you know, I'm not a TIPIC and I cannot sign, you know, a closing document of any form, be it a new loan or a refinance, modification, whatever it is. You know, we cannot do that. And I think that's one of the things that's confusing or making Maryland more confusing. And it's just Maryland and Indiana are the two states that require that TIPIC licensure, you know, in addition to your Notary Public commission.
Thanks, Marlene. The takeaway from that is you need to follow the laws in the state in which you are
Yes.
practicing, you know. So
Know those laws, know those laws, know those laws. Yep.
So Sharon T, your hand is up. Are you still on the call and do you have a question?
I'm still on the call. Just a small question. I'm trying to find out if I notarize a document, someone is there witnessing that document. Can I sign as a witness?
Say that again.
The document has a witness, and it needs a witness, but it also needs a notary. I sign it as a notary in Maryland, but can I also witness the person's signature? Because
Okay,
they
so
have
can you sign in the witness spot as well as the notary?
Yes.
As long as you don't notarize your own signature. I know
Okay.
yeah.
Okay, I just wanted to clarify that. Thank you.
There was when the law changed about remote ink versus remote online, and we were talking about wills and trusts and some exceptions for. There used to be an exception where if you were remotely notarizing, you couldn't sign in both the witness and the notary lines, but that also was undone at that time. And yeah, the key is to not notarize your own signature, though. Sometimes those witness lines, they ask you to notarize them. And if they ask you to notarize them, you know, of course, you cannot notarize your own signature. So,
okay.
Thank you, Sharon.
Thank you so much.
Of course. So the next person, Dr. Inamail.
Yes. Do we receive a certificate of attendance
For
this course?
No. This is not a required course. This is just simply our outreach to the notary community and those interested.
Okay, how about the renewal of our license? What supplements for it, for the renewal of our license?
There's a list of authorized course of study providers on the notary page of our website. If you're asking about what class do you have to take to meet the requirements to renew, the list of authorized course of study providers on our website, you can select from any of those on that list. If you go to sos.maryland, Maryland is spelled out, .gov, and you click to the notary page, there's a write-up about how the renewal process works. And on that same page, there's a list of authorized course of study providers, course of study exam providers. You select one of the providers off of that list, take the course, they'll give you the certificate. That's the actual course of study where you go through notary law, regs, handbook in its entirety. Whereas this, you know, this particular thing it's a town hall for outreach. We're talking about very specific subjects. Usually it's not an actual course of everything you need to know to be a notary.
Okay, thank you very much. I appreciate it.
You're very welcome. So we have 4 more hands up. We will respond to those 4. We are 45 minutes post the time. So again, we'll respond to those 4. If you have any questions beyond this, I will invite you to please reach out directly to the Maryland Insurance Administration or the Office of the Secretary of State with your questions. So next up is Porter D. Washington. Porter Washington.
Thanks so much. I appreciate your patience. So real quick, so just so I got the tip and TIPIC squared away, you tell me if I'm right or wrong. You got to be a notary. You have to take the requirements for a notary and be commissioned. Once doing so, you take the required classes and license and bonds and such. And then you either one, apply to be with a TIP, which is typically a company, or you work for a company, individual or company, or you want to be an independent contractor so that he can solicit you and you can post your fee for such as a TIPIC independent contractor in the state of Maryland only. Check a hold.
You've got the Maryland notary part correctly. I'm going to ask Miriam to address the TIP and TIPIC portion of it, since that's what she regulates.
Yes, thank you. There is only one license for the title insurance producer. The difference is when you complete and sign a waiver that you want to be the affidavit indicating that you want to be a TIPIC. The difference is really the requirement for that for the affidavit.
Confusing.
I don't know if I answer that.
No, your answers are very confusing.
I apologize. I'm trying to the best I can to respond to it. Can you please ask your question again?
So since
Maybe I didn't quite get it.
Since we got I think you answered it for me, but I'll reiterate. The notary part, we're good. The TIPIC part really is just in one instance, you work for a company to do the settlement deal. For the TIPIC, you're an independent contractor that you work for yourself. You do your 1098, your 1099, you're in demand, and then you get hired by individuals soliciting you for such.
Right.
The requirements for such are the same, but I think what the added information that you added is that if you want to go to be a TIP or TIPIC, the difference between the TIPIC as a contractor is that you have to do an additional affidavit. Is that correct?
In the application, yes, you indicate that you want to be a TIPIC.
Okay.
Yes.
Thank you.
You're welcome.
Bye-bye.
Thanks so much. Sandra Hall, your hand is up.
Yes, I'm here. Can you hear me?
Yes, we can.
Okay, so what I was just suggest is that maybe a chart can be put together, a simple chart that says, here are the requirements for a TIP. Here's the requirements for a TIPIC. Across from that, crosswalk, and these are the things you need to be a TIP. And in the comment section, maybe have a brief description of what it is. Something visual so people can see and understand and know the difference between them. Thank you.
Thank you, Sandra. So Miriam, we'll leave that recommendation with you for
Okay.
your consideration.
Okay, thank you.
Thank you. Nikki Thompson, your hand is up. Are you still on the call?
I am. Hello, how are you?
Thanks. How are you?
I'm good, thank you. I am a new notary, and lately I've seen notarized documents coming through where the notary will use the actual seal, and then they'll stamp on top of the seal. I thought we could use one or the other. Do we need to use both?
As long as they each have the name, the county, and the words Notary Public, they each count as a seal. So you don't need to use both. There's nothing wrong with overachieving and putting both on there. Some folks will put both because maybe their embosser has name county notary and it qualifies as a seal, but then they buy a stamp that just doesn't have their county or doesn't. I don't know why folks do that sometimes, but the embosser and the stamp are both constitute a notary seal as long as it has those three items: your name as it appears on your commission, the words Notary Public, and the county in which you're commissioned, or Baltimore City if you're commissioned in Baltimore City. So if they both, the embosser and the stamp, say those three things, they both count as a seal. You don't need to use both. You can use one or the other. But it's not wrong to put both of them on there, but you definitely don't have to if they both qualify as a seal.
Got it. Okay, Mike, this is Alicia, and I thank you for all of your help. Thank you so much. We're sworn in and we're ready to rock and roll. Thank you.
No problem, Alicia. Glad it all worked out. I thought I recognized that photo on the
Thank
screen.
you.
I was going to let it ride. You don't want to be wrong when you think it. So I want to say to embarrass myself. But glad you joined us, Alicia.
Thank you.
Thanks so much. Charmaine Jackson, your hand is up, and are you on the call still? Happy to
Yes,
answer your
thank
question.
you. Thank you. I am a federal government employee and I am listed on our agency's website as a notary, which means I get a lot of calls to notarize. Am I authorized to charge the $6 fee on federal government property, or do I need to step outside of the building to notarize for $6?
I would say that's between you and your employer. Maryland law authorizes you to charge up to $6 per notarial act.
Yes.
But if you're doing it on your work property, I want to consult your employer for their thoughts on that. But law allows you to charge it as long as you're in Maryland, you notarize.
Can I jump in here? This is Sandra. I am also a federal employee because she's a public servant as well as myself. You cannot charge, but again, check with your legal person. But as a public servant, we cannot charge. Thank you.
Thank you, guys.
All right, so thank you so much. Thanks for all the great questions. Secretary Amy, Commissioner Barain, thank you so much for welcoming us earlier. Mike Schlein, Marian Akame, thank you so much for the great presentations, and to everybody who participated today. I hope this town hall was informative and helpful. We will be conducting other town halls during the 2023 calendar year. They will vary. Keep your eye out for the emails will come through announcing them. Please feel free to drop a topic in the chat box or contact us if you have a topic that you'd like us to consider. If it's related to the Maryland notary law, the regulations, or the handbook, we're happy to consider these ideas if they are within the scope of our authority and if we have the capacity to do so. Again, the recording from today's town hall will be posted on the Office of the Secretary of State's Notary webpage, and it will be up in just a few days, so please feel free to refer to it as often as you like. And a final reminder, the content and presentation provided is for informational purposes only. It is not intended to be legal advice. Thanks again for joining us. Have a terrific day, and thanks for all you do. Take good care. Bye now. Bye-bye.